Hello again, everyone. Welcome to Washington Gun Law TV. I am Washington Gun Law President William Kirk. Thanks for joining us. This will be a video predominantly for the hometown crowd, but I need all of you to pay attention because it has to do with a very, very important argument that we have coming up here in Washington State. But what we're going to do today is we're going to dive really deep and take one tiny little aspect of this argument because it is an argument that I see popping up over and over, and I think the amicus party here in this case in Washington State has done an excellent job of addressing it. So we're going to talk about the big issue today, but we're going to really geek out on this one tiny little issue. So today, let's spend a few minutes and let's talk about the huge battle about to be waged in Washington State. Okay, before we get going too far down the road we're going down, proud to announce that this video is being brought to you by the same people who are bringing us the lawsuit of State of Washington versus Gators Guns. And of course, I am talking about the Silent Majority Foundation. Listen, they got their start during King Inslee's reign during our pandemic. They started suing on behalf of numerous constitutional rights, and as you know, have been defending your inalienable Second Amendment rights better than anybody else in this state. For many of you, you may not know this, but the Silent Majority Foundation is a not-for-profit operation, which means they operate exclusively on donations. Listen, the fight is near. We got this huge argument coming up that we're going to be talking about on this video. So please consider giving to our good friends at the Silent Majority Foundation. You can find them at silentmajorityfoundation.org or check them out in the description box below. Okay. Circle the date, Washington State, January 14th. That is when State of Washington versus Gators Guns, the constitutional challenge to Washington's high-capacity magazine ban, will be before the Washington State Supreme Court. As we know, a trial court in Cowlitz County found this law to be unconstitutional, both under the Second Amendment of the United States Constitution as well as Article 1, Section 24 of the Washington State Constitution. Bob Ferguson and his cronies crapped their pants. They immediately filed for the stay. They got it. That was the whole subject of a whole nother brouhaha, which I won't bore you with today. The stay has been continued, therefore the injunction that came out of Cowlitz County has never gone into effect, and now we sit before the Washington State Supreme Court January 14th. Silent Majority Foundation will be the lead plaintiffs in this case. Of course, Wally of Gators Guns is the lead plaintiff. Now, we're going to geek out on just one tiny little issue because, as you can imagine, when this is the person who is arguing on behalf of the constitutionality of Washington state gun laws, yeah, they're going to throw everything at the wall and hope that something sticks, which means they will make some of the most disingenuous arguments because, well, in this state, nobody's held this guy accountable yet. One of the most disingenuous arguments that the state of Washington makes as to why Washington's magazine ban is totally constitutional is because the only types of magazines that could ever be protected, or the only types of arms that could ever be protected, are those that are in common use for self-defense. Now, for all of you who geek out on this channel and a lot of other channels, we all know that the test is in common use. End of story. Okay? If you really wanted to add some extra words, it could be in common use for any lawful purpose. That's the test. For some reason, the state of Washington believes that no, we have to prove that this particular item is in common use for self-defense. This is an amicus brief that is actually authored by the good folks at the NRA, and they take this issue on quite well in this memorandum, and I want to geek out with you on that because I think they've done a very good job of dissecting this argument. The state errs by limiting the Second Amendment's protection to arms in common use for self-defense. To be sure, the banned arms are commonly used for self-defense, but self-defense is not the only purpose the Second Amendment protects. Heller explained that the rights protect weapons typically possessed by law-abiding citizens for lawful purposes, which made sense because the traditional militia was formed from a pool of men bringing arms in common use at the time for lawful purposes like self-defense. That's right. The quote in Heller is that firearms which are in common use for lawful purposes. That's it. And understand that lawful purposes can mean something far beyond self-defense. It could be as simple as I like to collect them, because if you are a collector of firearms, that is a lawful purpose. It may be that you are just into a particular type of platform of shooting, and it's not a firearm that you necessarily would use for self-defense, But do you like shooting 1,200 or 1,500 yards with your 6.5 Creedmoor bolt-action rifle or things like that? Clearly, a firearm that's not necessarily used for self-defense, are we actually saying, Washington State, are you actually claiming that none of that is protected by the Second Amendment? And let us remember that the Heller case, the genesis of all this language, had quoted a case from Tennessee with approval, which stated the following. Heller approvingly quoted the Supreme Court of Tennessee, stating that the right to keep arms involves necessarily the right to use such arms for all the ordinary purposes. But if Washington State is correct, then consider this. Aside from the fact that the banned magazines are commonly kept for self-defense, that they are commonly kept for other lawful purposes, such as hunting, target shooting, and competitive shooting, secures Second Amendment protection. So I want you to think about the dangers of this argument, America, because if in fact the test is going to be in common use for self-defense, then all of a sudden the court gets to become the gatekeeper as to which firearm is appropriate for self-defense. The American people would no longer get to choose what's appropriate for them. No, rather, it would be the people with the black robes. And the truth is when we're talking about in common use or the common use test, it simply is a numerical equation. And NRA correctly points out, the state defends its bans by asserting that the prohibited magazines have virtually no utility for self-defense and are even disadvantageous for self-defense. But that determination is for the people to make, not the government. That's right, they have virtually no use for self-defense or somehow or another are disadvantageous to self-defense. Tell that to the homeowner here. The relevant inquiry is whether the arms are commonly possessed for a lawful purpose. As Justice Stevens explained, the Heller Court struck down the District of Columbia's handgun ban not because of the utility of handguns for lawful self-defense, but rather because of their popularity for that purpose. So it really is a simple numerical value. That's it. And it needs to be a simple numerical value because that is how the power remains with the people. It is the people, the citizens of America, that are to decide what's most appropriate to protect their lives and the lives of their loved ones. As the amicus party points out, it is for the people, not the state, to decide which arms are protected by the Second Amendment. To limit self-defense to only those methods acceptable to the government is to effect an enormous transfer of authority from the citizens of this country to the government, a result directly contrary to our Constitution and to our political tradition. And furthermore, it would actually inject the largest interest balancing test humanly possible back into the Second Amendment equation, which is that people in black robes would begin to decide what is most appropriate for self-defense. And for those folks in Washington, we all remember when this person with a black robe decided to preach to all of us about what was appropriate for self-defense. No, the right to select which instrument is best suited for your self-preservation lies with the people. As the amicus party points out, rather Heller affirmed that the people have the right to choose their preferred arms. Whatever the reason, handguns are the most popular weapon chosen by Americans for self-defense in the home, and a complete prohibition of their use is invalid. That is the holding of Heller. And what Heller said is that the people had chosen this particular platform of firearm with such frequency that it absolutely positively was in common use for lawful purposes and therefore could not be banned. Just the same as the American people and the citizens of Washington have chosen millions and millions of times over to equip themselves with magazines which hold more than 10 rounds. That establishes the common use of these magazines for lawful purpose, and that should be the end of the analysis. But I want the state of Washington to also consider this, because what they are saying is that these are never used in self-defense because, there's only 2.3 rounds fired in an actual self-defense situation. Well, that's if we're going to say that the use of a high-capacity magazine in self-defense actually requires the firearm to be discharged. It does not matter how often a firearm is actually fired in self-defense. A firearm that is possessed for self-defense is used for self-defense even when it is not being fired. So listen, we've seen courts just completely bastardize the Bruin holdings in every way humanly imaginable, limited only by their own imagination to come up with ways to continue to uphold civilian disarmament legislation. Do I have faith in plaintiff's counsel here? I absolutely do. And once again, link down below to show the Silent Majority Foundation some love. Do I have faith in the Washington State Supreme Court to correctly apply the law? Well, let's remember that this is the court that also found that Washington State's capital gains tax, which is an income tax in 41 other states and according to the federal government, is not an income tax here in Washington State. Otherwise, it would have been struck down. So do I like our chances? About as well as I do if we go outside and throw rocks at the moon. Listen, we're going to go ahead and link up the case again. It is State of Washington versus Gators Guns. It's linked up down in the description box. Silent Majority Foundation is linked up down in the description box. Wally Wentz and Gators Guns is linked up down there in the description box. Show them all some love. If you got any questions about this or anything else related to what's left of our Second Amendment rights, you guys should know how to get a hold of Washington gun law by now. But if you don't, that's okay. That information's down there in the description box. If you got an idea for a video we should be doing, you click on that link right there. You let us know. We'll probably end up doing something because it's going to be better than anything we come up with. If you want to subscribe to our monthly newsletter, the ability to do all of that is down there in the description box. And then finally, and most importantly, let's remember that part of being a lawful and responsible gun owner, like we talk about all the time, is to know what the law is in every situation, how it applies to you in any instance that you may find yourself. Until next time, thanks for watching and stay safe.